Okay, good morning, ladies and gentlemen. Let me welcome to the third edition of our webinar series on AI governance. Today, focusing on the topic of protection of data rights for citizens and users. My name is Axel Hannes-Sievers. I'm heading the Heinrich Böll Foundation's office in Hong Kong. And this is a collaboration with between the HBF, the Heinrich Böll Foundation, and the Association of Pacific Rim Universities based in Hong Kong, in short APRU, with a co-organizer, a network of 60 leading research universities located in 19 economies around the Pacific Rim, with its secretariat in Hong Kong. It brings together university leaders, scientists to collaborate with policymakers, industry foundations, and multilateral organizations to collaborate on practical solutions to key challenges in the Asia-Pacific region. Its focus areas include climate change, sustainable challenges, including waste and cities, global health, and multi-hazards. AI and its impact on society, specifically in the Asia and Pacific region, has been a key focus in the work of APRU since 2015. My own organization, Heinrich Böll Foundation, HBS, is the Green Foundation from Germany, linked to the German Greens. It's an organization to dialogue and networking on themes at the heart of green thinking and of the global green movement, sustainability, environment, also democratic rights, social rights, rights of marginalized groups, with a focus on participatory politics. HBS works in Germany with its headquarters in Berlin and with about 35 offices all over the world. And it's active in Hong Kong only since 2020, with a specific focus on dialogue between Asia and Europe on issues of technology and other fields. Today, our topic is the role of data and the problems of data and data protection and privacy in the development of artificial intelligence. We are all aware that AI applications require a vast amount of personal data, which are being processed, used, transported, imported, exported in various ways. Privacy issues, data rights issues play a huge role in all this. And we are going to bring in a commentary and observations from 3 different angles today, with 3 speakers with whom I'm welcoming very much here. Our first speaker this morning will be Ms. Sarah Chanda, who is a senior policy advisor at the European Digital Rights, EDRI, who is leading there the work on AI policy and specifically the EU Artificial Intelligence Act, which is in discussion in the European institutions. Her work includes the development of specific recommendations on the EU AI Act from a fundamental rights perspective. The EDRI network itself is coordinating a wide coalition of more than 100 civil society actors on the AI Act. Sarah is also active in the field of racial justice as co-founder of the Equinox Initiative of Racial Justice. She's a racial justice and AI fellow at the Ada Lovelace Institute in London, and an advisory member to a number of initiatives tasked with ensuring inclusion and non-discrimination. Professor Jay Moon, our MJ Moon, our second speaker, is a distinguished professor at Yonsei University in South Korea, as well as a director of the Institute for Future Government. He was selected as one of the world's 100 most influential people in digital government in 2018 and 2019, consecutively by the Apolitical. He received the Order of Service Merit Red Stripe from the Korean government in 2020. And our third speaker will be Mr. Sanka Som, the Chief Innovation and Evangelist at Tata Consultancy Services, based in Hyderabad. Sanka leads the research and innovation evangelism for Tata Consultancy Services globally. And in this role, he acts as a bridge between TCS investments in research and development and the customers that TCS serves globally. He has been working with TCS over a career spanning 20 years in multiple roles, an undergraduate in computer science and an MBA from Indian School of Business. Yeah, based in Hyderabad, calling in. We are all calling in from different places, actually in Europe today. That's an interesting coincidence of that the hopefully post-pandemic traveling season has started again. We are very happy to have this kind of mobility back again. Yeah, so welcome to everybody. Welcome to all our participants who are in the background. Some advice for the participants: we are recording this session, as you have been noticed. We are asking participants to raise questions via the Q&A function during the presentations. We also encourage participants to share event info, tag HBS and APRU on social media. Yeah, and let's go into the discussion now. And our first speaker, as I said, will be Sarah Chanda from European Digital Rights Initiative. And I just want to ask her to give us a short, her take on the AI regulatory act, which exists in a draft in the European process, in the European institutions. What does it all mean from the perspective of data rights protection? What is new and useful in the AI Intelligence Act? Thank you.
Thank you very much, Axel, and thank you for the Heinrich Böll Foundation for inviting me here today. It's a pleasure to be speaking with you, and I'll try and give a summary of really from the perspective of data rights protection, what's new and useful in the EU's AI Act. Before I jump into that, I would maybe just give a few caveats. From our perspective, from the perspective of the European digital rights, what we're looking at when we think about fundamental rights protection with respect to the EU AI Act and the use of AI increasingly in more and more areas of our public lives, impacting people in all types of different situations, what we're thinking about is data rights and specifically questions of data protection. The use of personal data, Axel, as you mentioned in your introduction, but also a broader range of fundamental rights. Fundamental rights is the term used in the European discourse. So rights to social protection, rights to non-discrimination, rights to freedom of expression, etc. These are the types of rights we are also concerned with as well as the question of data protection, but also more broader than that, questions broader than this question of rights in an individual sense, but also how do these systems impact our society? How do these systems impact with broader forms of marginalization and inequality, and questions of economic justice, social justice as well? And really what I would like to say is specifically when EDRI and many of the organizations that we are working with, when we're looking to analyze the attempt at regulating artificial intelligence, is asking ourselves the question, how really are people empowered in the context of AI? So in many discussions about AI, we will hear questions about the potential invasiveness of the use of systems. And you mentioned the use of vast amounts of personal or data in general. We also often hear about the complexity of AI systems, and we also often hear about the opacity of those systems. So if we take these sort of statements as a starting point, how do we empower people in that context? One of the ways we try to answer that is recognize that people are not homogeneous, and the situations that they encounter AI through are often not homogeneous. So when we speak about different people, how they can be empowered, how can harm be prevented, we also have to recognize the different contexts, positions of life, different conditions of marginalizations that put barriers to their access to rights in the face of the use of AI systems. Particularly, let's think about how people with disabilities are impacted by the use of AI, let's say in the public space. Let's think about how racialized women are impacted in the face of AI systems. So there are many different debates when we even unpacking this question of how do we protect people. The second caveat I'll make is that all of what I will say today about what's useful in the EU AI Act is up for debate. We do not have a final text. Currently, we are in negotiations now. From the side of the European Parliament, we have earlier this year received a draft report from the two lead negotiators of the AI Act, and we have just undergone a process where MEPs in the IMCO, so the consumer related committee in the European Parliament, and the LIBE committee, the Civil Rights Committee in the European Parliament, have submitted their amendments. Now we will have the chance to go through them, and this will be a longer process for the rest of this year, deciding from the Parliament side a final text on the side of the European Parliament. On the Council side, we also have ongoing questions and debates, and we'll also see a longer process going into even 2023, where the European Commission, the European Parliament, and the European Council will have to negotiate their different positions to come up with a final text on the AI Act. So much of what I will say today relates to certain positions that have been coming from the European Parliament, specifically the draft report I mentioned, and some positions that have come from the European Council. Jumping in, I think for me, to answer the question in terms of rights protection more broadly, what is new and useful in the EU's AI Act, I would make 3 points, and we can unpack them a little bit in the discussion. The first thing that I think is useful is that a debate has started that there should be, at the very first line, a question about some forms of AI practices or data rights practices are inherently invasive, harmful, discriminatory potentially, and therefore should not be simply strictly regulated or should not be improved with certain technical measures, but should be prohibited from the offset. And many of you who are following the EU AI Act will know that there is an ongoing debate about certain forms of AI systems, and specifically the use of certain AI systems. For example, the use of facial recognition by law enforcement in public spaces, the use of systems like predictive policing systems, the use of systems like social scoring. Currently, the discussion is more about social scoring by public actors. All of these discussions, there is an ongoing debate about to what extent they should be prohibited and what certain language we should be using. I believe from my side, this is a very useful debate because we take as the offset debate that we are talking about the use of AI systems, first of all, not the systems themselves. And we are recognizing that we need to regulate these technologies in a social context not as abstract technologies without any contextual impact on people's lives. So that's the first useful thing that I think is arising from the EU AI Act. The second thing, and I think this is probably most relevant for the audience today, is that there's an ongoing debate on what rights data subjects or persons affected should have in the face of high-risk AI, which is the main focus of the AI Act. So with respect to certain categories of AI systems, which are also defined in the AI Act, mainly in Annex 3, and here we're talking about certain uses of AI in education, employment, law enforcement, critical infrastructure, they are listed. The question is, what sort of information, what sort of rights do people affected, what are they entitled to? And currently there's an ongoing debate about the right for people affected to be informed that they are subject to a certain high-risk AI system, perhaps that they should be given certain information, and also potentially in some cases that they might have to be explained about certain decisions taken with assistance of a certain high-risk AI system. Linked to that, there's also a broader debate about public transparency. So what sort of information should civil society or generally the interested public be able to access about the use of AI systems that are high risk? And here most relevant are two things. The debate about public transparency in terms of what AI systems, what information about AI systems should be available in the EU's proposed public database on AI. And then the second part of that is also the proposed obligation, which was also featured in the EU Parliament's first draft report on this act, is the obligation on users of high-risk AI to do a fundamental rights impact assessment. And that impact assessment to provide some information about the scope, the context, and the potential impact on people's rights of certain systems. The last point I would make, and sort of what is new and useful about the EU's AI Act, is the question, opening up the question about the right to remedies. So we know for those of us that are working on EU policy, there are some existing remedies with respect to processing of personal data already in the EU GDPR. What I believe is interesting about this legislation is that the EU AI Act, some of the Parliament drafts seek to increase the scope of this these remedies, specifically where the EU AI Act imposes new provisions on either developers or deployers of high-risk AI, and therefore taking that to the full extent, extending some remedies and rights to people affected. And again, going back to this means, again, the right to be informed about the being subject to high-risk AI, potentially the right to have some further explanation, further than the one attempted to be articulated in the GDPR, but also to have a remedy, for example, if you are subject to a prohibited AI practice. Now, these, I think, are very, we can talk a little bit about some of the details of these attempts a little bit further, but I think this is a very, at least, important opening for the question about what sort of rights should people affected by AI systems, what should they look like? How will they help people in a very concrete and practical way? How will they help people, especially in these contexts, as we've already heard, of opacity, complexity of AI systems in the public space? And so on that, with those 3 points, I'll close and happy to answer questions.
Yeah, thank you very much, Sarah. That was a very good introduction into some core issues of the process, and certainly raising possibilities for many more discussions. Let me go right away to Professor M.G. Moon, asking him from the government perspectives, from the perspectives of governments, what's your experience? Where should be the limits of access to data, and what roles would, on the other hand, government play to protect the data rights of citizens?
Well, there are many different stakeholders and institutions which and who are very keen at data protection. Of course, government is one of them. Citizen groups, of course, and also business, private sector companies as well. So that there are a number of stakeholders. But my interest as a student of public administration, I just want to share the perspective of the government. Well, the government side, as part of the digital government, I think there are several reasons why government has paid more increasing attention to data, personal data. The one is, well, the significance of the evidence-based policy decisions. So that policy decisions should be evidence-based, and which means that not only systemized data, but also personal data is very, very important to make good decisions and for the public interest. So the evidence-based policy decisions, and that requires government to use a lot of personal level data. Of course, there are privacy protection and personal information protection should be there. The second part is, well, there's increasing demand from citizens for customized and targeted services. So if citizens want to have good customized services, government should have personal data as well. So that's another reason. And shifting from one-stop service to no-stop, these days, no-touch service, which means that government should have good amount of personal information so that they can provide good, customized, personal public services. So that's demand side, why government should have a good amount of personal data. Now, the question is, the government should also be very keen at data protection, privacy protection. And so the government should, on the one hand, government should have good data governance through which personal information protection should be ensured. So on the one hand, good policy decisions, good public services to individual citizens, that's that's one goal. Another goal is that personal data protection. So of course, one is not can rule over the other, so that the both sides, it's like the two wheels, and I think it requires good social consensus among different stakeholders. Of course, citizens, whether or not, to what extent citizen willing to have their government use his or her own data. Of course, they consent, but they should be able to track what types of personal information is used and shared with whom, and if they want, and then they can withdraw. So that citizens should have the right to consent and then track and withdraw, and that should be shared. So that's one. The other one is that businesses, and these days, private sector, they want to use personal information for targeted services, private services. Of course, they want to develop new services such as financial services and public health services. They need personal information. Now, the question is, many people think, well, privacy protection is not there. And so that, the question is, what types of data governance you want to have? And I interviewed many people from the private sector, and they think too much regulation concerning personal data protection. And they say, well, that regulation suffocating future business opportunities. So here, to what extent you want to have better services, and then how you balance between quality of public services and then potential for business opportunities in future and privacy protection. I think it requires a social consensus among different stakeholders. And the other one I want to say is the data governance. Different countries have different governance systems. For example, in Korea, we do have Personal Information Protection Commission, which is an independent commission which put efforts for law and investigate any potential infringement of personal data violations. And also they coordinate with other stakeholders so that I think government need to have good data governance to balance among different policy goals. And the other one I want to say is there are technologies which help personal information protections. And of course, there are a lot of research institutions, they want to have personal data for research purposes. And then, of course, data should be pseudonymized, and then we can do that, though there are still concerns from civic groups. So that could be done through different technologies. And that's one. The last one I want to say is the governance structure, the one that I mentioned, Personal Information Protection Commission, for example, in Korea. And the role is very critical. One, improve personal information related laws and systems, and then investigate and take legal actions against the possible personal information violations, as I said. And then we should have good research, and then empowering citizens. Of course, citizens should be very, very aware of any potential risk, as Sarah mentioned. And then we should have good mechanisms through which we have good cooperation and coordination among different stakeholders. And I think that's something that I want to share today.
Thank you, Jay. You have been speaking largely about government perspectives and government organized institutions. And would you say there have been, from your Korean experience in particular, have there been particularly good or bad examples of handling these issues, where this institutional setup that you are describing has really worked either very well or rather particularly bad? Would anything come to your mind?
Well, I think from the perspective of quality of public services, citizens seems to be very happy for receiving personalized, customized public services. And they know their data and information being used by government. And then often his or her information is shared by among government agencies, different organizations. So I don't think that's a problem. The difficulty we have been facing in Korea. Last year, I had opportunity, privilege to coordinate the data governance, and that's why I interviewed many people from private sector and civic groups, as well as government officials. Government officials say, well, there is very low level of risk. But of course, civic group, they don't believe it. And then, business side, they have, very high level of complaints because government stepped in too much regulations. Now, the question is how you build good social consensus building mechanism, because public trust in government and data use is so critical. And I don't think that's the one that government can do by itself. And I think it should be international cooperations. For example, the Personal Information Protection Commission that I mentioned in Korea, they work with many other international communities, such as Global Privacy Assembly, Asian Pacific Privacy Authorities, and Global Privacy Enforcement Network. And then Council of Europe is part of that too. So it should be done not only individual country level, but also international level. And I think we need to have good coordinated efforts for that, because the balancing is so critical and challenging. But it's not optional, it must be there.
Okay, thank you very much, Professor Jay. Okay, Sanka. from a private sector perspective, you have been advising the private sector on issues of digital transformation. How do you think, what's from your perspective, and also from the perspective of an Asian country which plays a major role in for international IT applications and exports them both for the local market as well as an international player? How do you strike the balance correctly between making strategic use of big data and protecting the rights?
So thank you, Dr. Axel, for that question and the opportunity to be on this panel. And I also would like to thank Sarah and Mr. Moon for the very insightful comments. And I think that truly set the tone for the conversation. So I would like to try and answer your question by, trying to break them down into three different types of questions, right? So the first is, we sort of intertwine two terms, big data and AI, and I would like to sort of call out that these are, that while there is a mild overlap, these are very, very different terms, right? Because they're inherently different techniques that you're using on the data. So that's one bit of input that I would like to provide. The second bit is also trying to ask the questions that, is this the right time to worry about AI regulation? And so I'll like to share a few perspectives on that. And the third bit is that it's quite easy to say regulate AI, but there are some very serious technical challenges which I would like to highlight, right, in the inputs that I provide. So the first bit is about this whole, this conundrum about big data and AI. I mean, are these two really the same? So I think there are several nuances, right? So big data is about the ability to manage the input side of AI, which is trying to wrangle with large amounts of data. And primarily, if you look at big data analysis, it's mostly focused around trying to draw insights from the data, right? Whereas AI is about predictions, it's about prescriptions, it's about talking about, using the data to actually make decisions, right? And therefore, there comes the fundamental difference, right? And if you look at how you build an AI system today, on the input side, you would see several big data approaches being used, especially when it comes to collecting and preparing the data. But I would also like to highlight that there are several processing steps that are very unique to building AI systems. And most of the issues about AI actually come through these processing steps, right? And some of the issues that I would like to highlight are, to start with, things like bias, right? So biases, intentional or otherwise, can cause long-term harm to individuals and groups if they are not identified early on in the process. And biases, when you build AI systems, can creep in the way you choose data, right, on which you build those systems. But they also creep in from other sources, such as most supervised AI systems have a very critical step, which is data labeling, right? And to do data labeling, you either use technology or you trust crowds of people, of experts who actually label data sets. And if you look at it, a lot of biases can actually creep in from the way data gets labeled in building AI systems. The second is regulations and policies. AI systems need to conform to regulations that apply to both the input side in these systems, as well as emerging regulations on end use, like the AI Act, right? And in addition to these, these systems also need to conform to internal organizational policies that most organizations which are responsible have set internally on the governance of data, the fact that Professor Moon mentioned, right? The governance bit of data. The third thing which we often forget is also robustness of these systems. So do the AI system perform reliably? Are these systems opening up decision-making to new kinds of attacks? So there are several attacks today that are possible on AI systems, which have been opened up for public or private use. There are attacks such as data poisoning, model inversion, model stealing, etc., etc. And the reality is that the technical barriers to preventing such kind of attacks are also still in the infancy. So you might actually, do everything right and put out an AI system and then have it attacked. and that could have unintended consequences. So the then there's the question of ethics itself, and you could do everything right, but as Sarah mentioned, that does it harm somebody in an unintended way? Does it violate the fundamental rights of a human being? Is it explainable? Is it fair? Is it transparent? Right, and these are very difficult questions to find technical solutions to in the state that the technology is today. So the AI Act does raise a few of these, categorizations of systems, as Sarah mentioned, into prohibited systems, high risk, et cetera. From the perspective of the timing, I think it is well timed. So if you look at the landscape of AI use in the modern enterprise, in private sector, in businesses, you would find that at the moment, only somewhere between 1/3 to 1/2 of enterprises will even admit to using AI or planning to use AI in their business environments. My educated guess at this moment is that only a very small minority actually end up putting AI into production. And mostly these are, in areas where there are efficiency gains to be made. But what is interesting is that there is a very sharp growth in both the intention and also real deployments over the last few years. And so therefore, when it comes to the timing of the act, one could look at it in two different ways. So either we are crying wolf too early, or we are making sure that as there is a chance for us in history now to that we are trying to make sure that as AI adoption increases, it increases responsibly, right? So that's the question on timing. Finally, when you look at the technical challenges for the industry to solve, there are several. Take data consent, for example. In GDPR, there is this whole, think of consent withdrawal. And when you actually withdraw consent in GDPR, you have to go back and delete every element of the PII that is held onto systems, right? Now, when you look at the way AI systems are built on millions of data points from individuals. And when one of them withdraws consent, thankfully under GDPR, you don't have to go and retrain the model, but then there is a big loophole left, right? Since the model incorporates the data of that one individual who has now withdrawn consent, there is potential an attack possible through which you could actually identify the individual by querying the model itself, right? So what do you do in such cases? The technology to solve that problem has not evolved. And finally, the other bit is also important, which is especially the high-risk system. I see in the Act there is a mention of using third-party certifications. Now, things like biases, right? So biases are like software bugs. You cannot guarantee a software system is free of bugs. Similarly, you cannot guarantee today, at least, that data that you have chosen to build an AI system is certified free of bias. So how do you, deal with such technical complexities and issues? So back to you, Axel.
Thank you very much, Sanka. I was just stumbling over one remark to say biases are like bugs. Does this really reflect the reality? Isn't it that the biases actually reflect sentiment? That biases are not just kind of technical bugs, but in the sense they are kind of reflecting systematic problems we have in society or in the data material, which again reflects society.
So see, there are intended biases, but there are also unintended biases. So if you pick data in a wrong way to build a system, while you are not, you are not malevolent, but the act of that mistake could actually have really serious long-term consequences for individuals or groups. So in that way, it's actually a bug in judgment rather than a bug in software, right? So it's a bug in your judgment, in the way you're picking data to actually build AI systems. Right. So I mean, and of course, there are intended biases as well, and let's not go into that. That's definitely there. I mean, as wherever there are humans, there are biases, intended or otherwise. Back to you.
Yeah, thank you. Because well, we leave out the malevolence for now, but even I think we have systemic issues which have been identified pretty much in recent debates. I mean, about the role of bias in NI and how to battle it. Let me first of all, let me just thank you for these initial comments. Let me also encourage the audience to put in some questions right now. It's not yet really coming, so let's just continue this on the level here of the panel. Let me go back to Sarah and ask her for comments on the presentations that you may have. Of the presentations of Jay Moon and Sanka Som. Specifically, I think maybe from the perspective of somebody who probably, if I sense it correctly, has a more adversarial model of policy making. I mean, with a strong role for civil society, a strong role of rights with which you can go to court to sue institutions and partners. How do you look at the suggestions that have come from our co-panelists?
Yeah, happy to give some reflections. So for the first point about, so I think Professor Jay Moon's point about, I would say I really, they resonated with me specifically from the perspective of the point about there need to be a broad consensus about the use of data in governance, and that needs to be, the focus on trust does need to be built. I think the way that that's done maybe is quite a complicated question. So, and I think it has to be done with respect, both with international institutions, as you mentioned, with governments, indeed. But I think there's also the question, and this is coming up a lot in the AI Act, is to what level is also that seen as not just a question of trust, but of accountability. And specifically accountability to those impacted, those who the data is about, or as Sanka really helpfully clarified, those who decisions are made about. So more in the AI side of this, it's not just about the abstract analysis of big data, but it's specifically about making inferences, predictions, decisions, etc., about people, and recognizing that those have real impacts on people's lives. So just to give a few examples, in the EU context, we are talking about a range of different decisions when it comes to the decision about whether someone is likely to commit fraud in the context of their welfare statements, as we've seen continuously in the Netherlands, about whether police can truly make a prediction about whether certain types of people that live in certain types of neighborhoods are more likely to commit crimes, or whether people have a certain emotion when they are making certain facial movements as they sit in front of their screens, let's say students, for example. So these are just questions about those individuals specifically impacted, but they're also broader societal questions. And that's a question not just about trust, but also accountability. And taking that even a bit further, accountability to who? The question about policy making also assumes, I think, to some extent, a universal citizen, and is often these conversations are not complex, they're nuanced enough to think about also the different positionality, the different subjectivities, the different vulnerabilities of people in different contexts. And that, I think, relates to your point, Axel, about the systematization of some of these questions. I thought the interaction on bias was very interesting. And I think maybe Tina can share this in the chat if we have a chance. We commissioned a report very recently to think about this question in AI regulation on the question of biases and how do you counter them. We were finding, at least I can only say with respect to the EU AI Act, that the question of bias was happening on a very technical level, with the presumption that it could be combated. So for example, taking this very famous example of facial recognition systems that do not work well on different people, specifically women with darker skin tones. That conversation and that example, I think, has quite framed the debate on bias with respect to AI in a very specific way, which has led the conversation down the road of focusing mainly about technical bias, but also about accuracy and data quality, which I think is very important, especially as you increasingly see through digitalization the use of these types of systems more and more in areas of public life. So for example, if you have to have facial recognition in order to access your apartment system, it better work on everybody. Otherwise, that's a completely unfair use of that type of technology. However, that automatic jump to data quality, that automatically jump to this technical conception of bias, skips over the question of should that technology be used, but also obfuscates a broader question. And I think that was what you were alluding towards, Axel, is that there are some types of systems that if they use data from the real world, they will always generate a harmful decision, prediction, or inference. And that's, I think, in that context, the predictive policing question is a very good example. So is there a way to debias predictive policing systems if they use policing data, which is inherently discriminatory in that police often over police certain communities, often poor people, often racialized people in the European context, etc. In India, often Dalit neighborhoods, often Muslim neighborhoods. So this is also a question about societal questions of bias as opposed to technical questions of bias. And those, I think those conversations need to sit beside each other. We need to have a good question about debiasing technologies when it works. But we also need to have that moral question, that legalistic question, and also that systemic question about will that AI system always produce a harmful or discriminatory result? And that in that context, in that latter context, is why we need to talk about governance solutions, greater accountability to people affected, but also at the end, in some cases, in some narrow cases, prohibitions on certain uses of technology.
Yeah, thank you, Sarah. I mean, what you are saying fundamentally even seems to involve an idea that, let me say, the checking of data and the checking of data against biases can actually be used to create a data set which more conforms with the values that we want to see in the society rather than those that we actually see already on the ground. So this is an interesting small example of a certain, that you can actually start some social engineering on data, maybe. And this would perhaps be another debate to what extent actually AI applications could be used to actually actually improve upon existing social realities by actually making sure that they reflect values in the data that we actually want to see, rather than those which we have on the ground, which may be actually pretty much deficient. It's just an idea that I want to throw in. I don't throw in here. I don't know to what extent that's actually technically possible, but it certainly opens up such possibilities. Perhaps I don't know, Sanka. Is that really are such possibilities there, or are we? I mean, you seem to take the perspective that actually most of the AI that is actually in use is much more mundane, is much more bread and butter issues that rather than affecting this. And I see a certain gap in the debate around AI, that on the one hand we have this dramatic examples of bias and actually really dangerous applications. On the one hand, which I think which actually play a prominent role in the debate. On the other hand, we have the demand for accurate services, pretty everyday things that citizens demand. Companies want to provide smooth services. I mean, how do we deal with this wide spectrum of possibilities in the AI when we have to create legislation around it?
Yeah, I think that's that quite accurately sums it up, because I would say it's a Pareto type of use cases, which is like 20% of the use cases are driving 80% of the debate. But you're right. If you look at most enterprise uses of AI, they are mostly targeted towards greater efficiency in very mundane processes, right? Like invoice processing, like, trade finance, like, the way you, the safety applications, right, on the shop floor and so on. Right. So, the one thing that I would like to highlight, see, there are, of course, larger, very important points about predictive policing that Sarah brought out. There were also several, inequities in vaccine distribution, for example, right, where AI systems were used. And I remember an interesting use case from, I forget which university, but I think it was Stanford, where frontline workers were not able to receive vaccines. So, the way I would sort of like to address this is that you got to understand that when it comes to, now if you take 80% of those mundane enterprise tasks, right, where you could actually unlock significant efficiency gains, make people's jobs better in the workplace, you would find that the cost of building those systems today is still very, very high, right? And I just, I just wonder whether, if we are not able to draw that line between low risk system and high risk systems and prohibited systems very, very accurately, would it increase significantly the business case for doing AI in the enterprise to actually sort of automate some of the mundane jobs that exist today in enterprises? And that's a worry that I have, that if we are not very careful in how we categorize AI systems, it might just weaken the business case for adoption of AI in the enterprise, and that could be a serious challenge going forward. So we are, reading the nuances of the act very, very carefully, and hoping that it does strengthen the good use of AI, and definitely prohibits the bad use of AI. I hope that answers your question.
Yeah, thank you. Thank you, Sanka. Let me put this a bit forward to Professor Jay Moon. Jay, many of the examples we have seen in of blatant biases in AI applications are coming from coming from European settings. I think Britain.
Yeah, in
I
Korea
think Sarah,
too, it's very.
Yeah, is it my question? What do you see from Korea, or maybe from East Asia in general? Do you have similar observations?
There are lots of cases actually. AI is very problematic in terms of bias and prejudice. We all know that. Some of the chatbots and facial recognitions, a lot of bias and prejudice is there. And we do have in Korea, one case, chatbot called Iruda, and there was a big issue in Korea a year ago. And now government really tried to coordinate AI governance. I know there are more than 100 of ethical guidelines for AI, mainly by private sector like Google, and many other tech companies, but also there are guidelines put together by international organizations, EU, UNESCO, and things like that. And in Korea government, for example, Ministry of Science and Technology Information, and they convened AI ethical forum through which a lot of stakeholders, people from academia, researchers, private sector developers, and citizen groups, consumers group, and they all together and discuss what types of things should be checked from the design stage to user stage, so that the Iruda, the one that we had a problem a year ago, and now that company is working with the government, and we put together a checklist so that we hope that that checklist used by private sector from the beginning of the design stage. Now there are checking points that make sure that they follow the guidelines, some of the principles they should pay attention to. Now, mostly my observation is that whenever it's not regulatory framework, very suggestive in ethical guidelines, but many private sectors they see as regulation rather than guideline. So there is perception gap between the two. And the other one that I want to mention is that, and those people who have looked at UNESCO AI guideline, there is AI impact assessment, so that when you design and how that impact, and that should be assessed from the early stage. And I think that's very, very important. And then here, of course, it's not mandatory, but there should be some mechanism through which the developers should pay attention to some of the ethical principles from the beginning. And now their lack of participation from the civic group and ethical ethics experts at this point, mostly developers in the private sector, they're very strong participants. So we should have good balanced AI governance as well. So, and I'm speaking from the perspective of institutional arrangement, even for AI governance. So yeah, that's still early stage. So, and I put together like, moralizing AI rather than regulating AI, because we are not that stage yet. But moralizing AI, that's mostly happening these days. Back to you.
Okay, thank you so much. Moralizing AI. This is a pretty different approach to the, I think, to the approach taken in the EU, which is, which I think likes to see itself as a forerunner in many areas of regulation of modern digital technologies, right? Maybe I should put this back to Sarah. You are standing at the forefront of these debates in Brussels. I think the GDPR, for example, is seen in many parts of the world as a kind of standard which other jurisdictions may have kind of then relate to, implement at least at part, or so have to relate to in any way in order to continue business with Europe. There's this AI Act that we foresee. Is it likely to play a similar role, particularly from the data protection and data rights perspective? What do you think, Sarah?
Yeah, so first of all, I think I would say that actually maybe the EU also followed a similar process of, the term wasn't used, but like moralizing AI too, right? Like they're way prior to the stage that we are now. There were many conversations, expert groups, white papers drawn up, etc., with the like a more broad like conversation there around like the ethics of AI systems, much more guideline oriented. So I think that also was a phase that the EU went through too. So I wouldn't say that's such a different process, but maybe coming out of that to now that we're more in a regulatory phase, we're definitely, yeah, thinking about the question more of regulating now, when the question of moralizing kind of was done, to use the framework that was already used. I also think from the part of that moralizing phase was also this, a lot of implicit sort of policy assumptions about the need for AI. So the background to the EU's AI Act was sort of two pillars that the EU put forward, the European Commission put forward, and one was the pillar of trust, really about these questions of ethics and public accountability, etc. The other pillar was of excellence, and under that excellence were a number of policy assumptions, and one being that the EU as an institution should be promoting the uptake of AI systems. And that, I think, speaks to what Sanka mentioned about these more mundane also use cases of AI, the assumption of efficiency gains, etc., etc. The notion that actually the broader digitalization agenda is an inherent good in itself. I say these are policy assumptions because also I think many of them are true, and we see many important use cases. of how AI can increase efficiency. But I think what was underexplored, at least at the EU level, was the interaction between the power of the private sector over all areas of life, whether it be the optimization of services, the delivery of public services. And so these are questions that maybe seem mundane, but also through the uptake of AI as a policy ideology, inherently increase the role of the private sector in the delivery of public services or just general services. And going back to the question on biases before, I think there are many mundane examples of potentially the question of harms that might not be categorized as biases, but that came through in these broader sort of mundane applications of efficiency, where efficiency was given the question. And we didn't also ask the question of efficiency for who. So for example, the Waze example is always a good example of that, which I've heard from Dr. Seda Gerses, who works at Technical University Delft, who explained to me, okay, Waze is an example of the optimization of public services like Google Maps. We had many examples of that system redirecting people to certain streets, and that also aligned with the how far certain local businesses were paying for advertising through that system. So there's also this question of optimization of public services, private interests, and the question of profit, which also comes into this question of the uptake of AI too. And increasingly, as we promote uptake of the AI, we're also promoting, to some extent, profit motives and the role of the public sector in defining the question of how efficiency works, etc. So that's just to comment back on that. And then to your question, Excel, the EU very much sees itself as a forerunner. And that is, I would say, in almost every conversation I'm in about the EU AI Act, this question comes up, okay, that we, in this policy conversation, that we will be setting rules that will be either followed or influencing different forms of AI regulation. Maybe to some extent that's positive, to some extent it's not, right? Like I think there are many positives, and I think this debate around increasingly empowering people in the face of AI could be positive and could have positive effects. But I think this illusion of, or this elision of this question of like the broader power, economic power infrastructures that the promotion of AI takes, I think that has a negative effect. If we don't really deal with that question, that could potentially have a negative effect. And for those following the EU AI Act, the question that's currently going on with respect to how we regulate general purpose AI systems may be starting to open up that question about AI, public and private power, and the role of big technology companies in that. Yeah, and I think that broader than that, there's also the question of Eurocentrism, right? So yes, the EU is maybe the first to do this large type of compulsory regional level regulation of AI, but that doesn't mean they have all the answers, and we have a lot to learn from other areas of the world.
Yeah, thank you. Thank you, Sarah, because this is actually, I mean, we are virtually through with our 1 hour time allocation here, but maybe I'm allowed to extend this for a few minutes because this is really leading us to the question, how is this seen as a useful forerunning role in other parts of the world, the role that the EU plays with this AI Act? I mean, we are having this kind of discussion right here, which is the kind of dialogue, yeah, that is really needed to come to some, maybe not global consensus on AI regulation, but maybe exchange about best practices, certainly exchange of viewpoints. But if you look at it, I mean, Jay, for example, for the Korean debate, does this EU initiative play a useful role for the Korean process? The same question I could also just ask to Sanka. Just maybe a final short comment on this. How is this perceived in Korea? How do you judge this? Will this bring the dialogue forward? Will this bring legislation forward? Good
in Korea, we pay very close attention to what's happening in EU. Some of the conversation, some of the recommendations and initiatives, we actually pay very keen attention to what's happening there. And that helps us to organize our thoughts and working with different stakeholders as I said, the industries, academia, and civic groups, and businesses, so etc. So that yes, it's an ongoing dialogue, and it's a very sort of semi-structured governance at this point. So as I said, so we are shifting from moralizing stage and then toward regulating stage. And regulating stage means that, if there is a violation, there should be penalties. So that it's a legal aspects. Moralizing stage is more loose. So I would say it's still moralizing stage, but we are moving toward regulating stage. And I think that's sort of a general trend we have seen. And definitely Korea is one of them.
Yeah, thank you. Sanka, do you have comments from an Indian perspective?
Yeah, so I think the Indian condition is that I think we're still coming of age when it comes to data privacy itself. So I think AI Act at least would be of interest at the moment in the academic circles, because the public usage of AI has to be at a level where it necessitates such an act. But data privacy and Data Act is something which is, I think, at the moment coming of age. So, but worldwide, I see many other countries actually pushing forward such regulations. I think Canada, if I'm not wrong, had a automated decision-making EDM regulation. The US is putting forward an AI regulation. So is so are the UK and potentially 4 or 5 other countries. So yeah, definitely, as I think it's a function of adoption, right? As public deployments of AI systems reach a certain critical threshold, you would see more and more of this, these kind of regulations coming into the picture. Back to you.
Thank you so much. Yeah, this brings us to the end of today's session of the third of this webinar series that we have done on the AI, on the occasion of the AI regulatory legislation draft that exists. And I think we have been able to really organize some dialogue from different parts of the world around an initiative that was originally a legal initiative that was originally started in Brussels, but which of course will have broader implications. It's very difficult for me to speak about take-home points right now. But one strong message I've really taken is that there may be no such thing as a mundane application, which I had in most. I mean, we really have to be very, very careful. We have to search for the very clear, we have to search in detail for the implications that even apparently mundane applications may have, while at the same time allowing that there is a lot of bread and butter activities taking place, of course, in the world of AI application, and that the debate around finding the right balance between protection of personal rights, protection of data rights on the one hand, and the interest of driving applications forward, of driving technology forwards, of building useful, trustworthy applications that is in the interest of the general public, that this is a tangent that is going to keep us busy for a long time to come. And we all of us who are sitting here will be part of this. And I thank you very much, Sarah, Jay, Sanka, for your contributions. I also want to thank the participants in our webinar series, all speakers that we had in earlier sessions, and the background team that has been enabling us to do this, Lucia and Carol on the side of HBS, Tina and Christina Schönleber from APRU. Thank you very much, and hope to see you again at a related event in the future. Thank you very much, and bye-bye.
Bye.
Bye-bye.
Thank you for having me.
Thank you.
Super. Okay. Oh, now we are